Morning. This is a compulsory discipline case brought against Mr. McGraw based on his conviction for intentionally causing to a child serious bodily injury and serious mental deficiency, impairment, or injury, which was, he was convicted in the 59th District Court of Grayson County, Texas. The Commission's petition for compulsory discipline was filed on August 17th of 2016. The first amended petition for compulsory discipline was filed on November 14th of 2016. Mr. McGraw was served personally with the first amended petition and notice of this hearing on December 1st of 2016, and notice of that, the proof of service has been on file since January 6th of 2017. On or about July 21st of 2016, Mr. McGraw was charged by information with intentionally or knowingly causing to a child serious bodily injury and serious mental deficiency, impairment, or injury in cause number 067190, styled State of Texas versus Michael Garnet McGraw in the 59th District Court of Grayson County, Texas. On July 22nd of 2016, a judgment of conviction by the court, waiver of jury trial, was entered in the same cause number against Mr. McGraw, wherein he pled guilty to intentionally causing to a child serious bodily injury and serious mental deficiency, impairment, or injury. And he was committed to the custody of the Institutional Division of the Texas Department of Criminal Justice for a total term of 20 years. The Commission offers the following exhibits. Exhibit number 1 is a certified copy of the information entered in the underlying criminal case. Exhibit number 2 is a certified copy of the judgment of conviction by court, waiver of jury trial entered in the underlying criminal case. Exhibit number 3 is the original affidavit of myself attesting to the fact that the respondent is the same person as the person identified as the defendant in the underlying criminal case. And lastly, exhibit number 4 is the original certificate from Blake A. Hawthorne, the clerk of the Supreme Court of Texas, dated January 3rd, 2017, which indicates that respondent is licensed but is not currently authorized to practice law in Texas. Petitioner offers 1 through 4.
Admitted.
May I approach?
You may.
Petitioner seeks an entry of a judgment of disbarment based on Mr. McGraw's conviction for an intentional and a serious crime.
Any questions from any panel members?
I have 2 questions.
Sir?
One is to make sure the status is that this is a default
Is a default
status.
The hall, Mr. Truitt sounded the hall, no
But
answer.
no answer was filed
Correct.
either. The second is this: could you comment on the definition of serious crime and therefore intentional crime encompassing this terrible crime?
Sure. I actually, if I might step back and grab my rule book.
Thanks.
Thank you. The definition of serious crime, leaving out the things that don't apply here, is any felony involving moral turpitude. And then the definition of an intentional crime is any serious crime that requires proof of knowledge or intent as an essential element. And what BODA looks to in these cases is whether the least felony offense under the specific subsection of the statute under which the respondent pled is an intentional crime. And you'll note that he actually pled, so the conviction documents are slightly different from the indictment, meaning that the conviction, he actually pled to intentionally causing the serious bodily injury and serious mental deficiency, impairment, or injury of a child. And so it's the Commission's position that the specific subsection to which he pled falls under the definition of the serious crime, in that it's a crime of moral turpitude, a felony crime of moral turpitude.
Any other questions? Thank you, Ms. Stevens. We'll take it under advisement.
Thank you.